Good morning. Good morning, members. Welcome to the the Bills Committee on Family Procedure Bill. We have formed a quorum and it's also the appointed time. Let's start our meeting now. The first thing on the agenda is a meeting with the administration. Please invite the administration to join us now. Please invite the administration to join us. Members, please note that on the 24th of March, our legal advisor sent a letter to the administration. It's paper number CB4227/2023-04, and there is also a response from the administration. It's a paper CB4235/2023-01. Members, please note the two papers. I'll first give the floor to Ms. Patricia So, Deputy Judiciary Administrator, Policy Support, to brief us on the bill and also walk us through the paper. And then I will open the floor to members. Ms. So, over to you. Chairman and members of the Bills Committee, good morning. I would like to brief members on the legislative background of the Family Procedure Bill. Now, our family justice system embraces a wide range of subjects covering family and matrimonial matters. They are now being dealt with by the High Court and Family Court, exercising concurrent jurisdiction, and then the court-related procedures for these matters are convoluted and dispersed over many pieces of primary legislation, multiple sub-leg, and array of practice directions. Now we have the High Court Rulemaking Committee and also the District Court Rulemaking Committee, and that is not really desirable. Sometimes it's controversial when looking for the right rules to deal with family causes in order to enhance the efficiency in the disposal of such matters. The former Chief Secretary accepted the recommendations made by the Working Party on Family Procedure Rules. 133 recommendations are contained in the report of the working group. Now, the major recommendations include to adopt a single unified set of family procedure rules, which covers and harmonizes different processes and procedures for family and matrimonial matters. And then to establish a new Family Procedure Rules Committee, FPRC, as the single rulemaking authority to ensure that the rules FPR are coherent, cohesive, and consistent and tailor-made to tackle family proceedings. And the third proposal is to set up a new family masters systems under which the registrar and masters of the family court will be empowered to take up certain case management functions that are relatively simple in nature of family judges to alleviate their heavy workload, and they can be dealt with in chambers. So the bill seeks to implement these procedures. It will set up the primary legislation in order to set up the FPRC and also the FPR. The legal basis will be provided for in the bill. We have to stress that the bill would only consolidate and improve court proceedings. It will not change the substantive law and policies related to family and matrimonial proceedings. Such policies are being dealt with by the relevant bureau of the government. Upon passage of the bill, the FPRC will be set up under the primary legislation to make a set of FPR which will be subsidiary legislation subject to the negative vetting by the Council. The procedure or the rules will cover 60 parts to provide comprehensive and more specific proposals, including the commencement of proceedings, procedures of applications in children, procedures, interim remedies, enforcement of court orders, etc. All these will minimize the need for users to check and cross-reference other pieces of legislation. And the procedures will also enhance the powers of the court to strengthen the use of alternative dispute resolution, such as mediation, to promote expeditious case disposal. The language or definition will be unified, and it will cover various family and matrimonial procedures. Some old terms such as supplementary remedies will be replaced by terms such as financial orders. The court will also define the jurisdiction and powers of the family court, and also the procedures for transfer of court proceedings. And three major principal ordinances and some subsidiary legislation will be amended consequentially to ensure that the whole system is consistency. The commencement will be divided into 3 stages. We have to establish the FPRC first so that it can start its work early for making the FPR. And we hope to set up the family masters system as soon as possible to provide immediate relief to the heavy workload of judges of the family court. And so the relevant provisions will come into effect as soon as the ordinance is enacted. For the remaining provisions, they will be commenced at a later stage, that is after the FPR is ready for commencement. As regards consultation, in February last year, we consulted the public on the bill, in particular stakeholders and legal practitioners. Feedback received was positive. The Administration of Justice and Legal Services panel expressed their support for the bill in August last year. And in light of suggestions from the amendment of the panel, we have adjusted the composition of the FPRC to add more professional representatives. The bill will make the family justice system more cost-effective and user-friendly. The judiciary will continue to implement measures to enhance the cost-effectiveness and efficiency of family justice system. I pause here. I'm happy to take questions from members. Thank you. All right. I open the floor to members. Each member can have 5 minutes for both questions and answers, but we can have many rounds to ensure members can understand the policy background of the bill. All right, 2 members on the list. Dr. Teck Chi Yun, thank you. We don't have too many members present. Can you be more flexible? Yes, for sure. I will give you ample time. First, I'd like to express support for the proposed amendments. As mentioned by the administration, the current arrangements are rather convoluted and fragmented. We need a unified system because when it comes to family disputes, I mean, it's a bit difficult for laymen to understand. If we have a unified system, that will be helpful because that will save the problem of causes being heard by different courts. And so I support the direction of the bill. Now, using common sense, we now have different courts to deal with such proceedings, but then they will be dealt with by one single court. Will there be unfairness as a result? Because some amendments are involved, will you be able to take care of different cases well? there be a negligence or oversight of some cases. I'd like to know your assessment in this regard. And secondly, we were told that public consultation was conducted. I'd like to know more about this. When you consulted the legal sector, can you tell us their concerns and their views or reservations? Has the legal sector given any feedback of this kind? I'm from the social welfare sector. We deal with many family cases, and sometimes proceedings are involved. Have you consulted the social welfare sector? How was it done? Because many members of my sector are not too sure about the amendments. Have they expressed concerns and issues for you to follow up? Thank you. Dr. Tick. Judiciary? Can I defer to Mr. David Lau on the proceedings as well as the consultation? Thank you. With regard to procedural justice, we are just consolidating existing procedures to streamline them. I'm sure this can promote procedural justice because in hearing family cases, there are sometimes no legal provisions for certain procedures, and cross-reference and checking of case laws are required, and that would mean extra resources and time. After the current exercise, we will make the procedures user-friendly and there won't be any ambiguities. As a matter of procedural justice, there should be enhancement. And we also take this opportunity to do away with some of the additional hardship to parties already in distress. The legal professions, including the Law Society and the Bar Society, have given us specific suggestions, and they've been incorporated into the current bill. For instance, the two legal bodies asked whether there can be more representatives to be included. There can be professionals with knowledge on mediation. Perhaps they can be included in the FPLC. In light of the views, we have increased the number of representatives from the two legal bodies. Hopefully, they can identify people with expertise in mediation to join the committee. And there are NGOs and social welfare organizations which provided views to us. They gave us views on policies related to family justice system, and that is not included in the current exercise, and views have been forwarded to the relevant bureau for follow-up. So we have received such views, and they have been relayed to the relevant bureau. May I follow up, Chair? Sure. Yes, please be flexible. A short follow-up. I hope the administration can bear with us. We are laymen in legal matters. Now you have streamlined the procedures. Now, what about the custodial right? There are very frequent disputes leading to secondary hurts. So can you tell us how such things can be streamlined and how can you relieve the hardship on the parties? Can you give us some examples? I'm quite concerned about consultation of the social welfare sector. Have you got records for our information? Tell us the specific views and feedback of the sector. They may have commented on the procedures and other things. I'd like to know the response of my sector. Can that be acceded to?
政務長係。
Judiciary. This will be a piece of principal legislation. On the procedures, those will be dealt with in the subsidiary legislation. At that point, we will also have a round of consultation. At that point, the legal professional bodies, social welfare bodies, and members of the public can give us comments. Because at that point, we will be talking about how the rules will work. Now we're focusing on the principal legislation. So for now, the well-being, the interests of children will be the paramount consideration. So this is the overall principle, and we want to achieve this. But the nitty-gritty will be spelled out in the regulations, the rules. On the consultation for this bill, we received comments from various bodies. Hong Kong Committee on Children's Rights, Family Association, among others. We received comments. We did not publicize these comments. If needed, we have to check with these bodies to see if they are willing to let us make public or share such comments. We did not make public their comments, so we have to do some checking. Chair, a simple question. In the future FPRC, will there be representatives from the welfare sector? Chair, there will not be representatives from the welfare sector on the committee. The Family Procedure Rules Committee will be tasked with setting the rules. So the FPRC will be made up of legal professionals. We're modeling this setup on the High Court Rules Committee and the District Court Rules Committee. So those committees are made up of legal professionals. Now, before Mr. Ambrose Lam speaks, I want to remind members that for this principal legislation, we will also do public consultation. After this item, I will deal with that. But just a reminder up front so members can take note. Next, Mr. Ambrose Lam. Thank you, Chairman. This bill can help streamline procedures and also lessen the resentment of the parties. After all, this bill will mean problems can get resolved quickly. And this bill can also restore peace and quiet for children that see estrangement of their parents. Discussions have taken place involving the legal professional bodies, the Law Society, and the Bar Association. And then the government arrives at this bill. So I support this bill. In fact, I'm selling this bill on behalf of the government more than asking questions. So I would like to see this bill being scrutinized quickly and passed quickly. So that's a comment from Mr. Ambrose Lam. We have allowed time for members to speak on policy so that other members can ask questions. Chair, I consulted the legal practitioners and bodies. They have no objection. They want to see this bill passed quickly. Point taken. Next, Ms. Doreen Kong, please. Thank you, Chairman. I went through this bill, but I don't see where the improvement is. The devil is in the details. So there will be this Family Procedure Rules Committee. I asked women who went through divorce. The problem with divorce is that people know how marriage works, but many people struggle with the divorce proceedings. At family courts, there's a floor where women can staple their documents around the photocopier. They get together and talk about things, but they struggle with what to do. And it's hard to access lawyers in Hong Kong. Lawyers are costly to hire. Chairman, you mentioned public consultation. I think that's a necessary step. Let's look at this proposal. Are the legal professionals or the courts the ones who want to get this passed quickly, or is it something the public want? If this is not something that benefits the public, then there's little point. Chairman, if we do the consultation after the clause-by-clause scrutiny, that would be too late. As a member of this Bills Committee, I want to see certainty. When you have the FPLC, then you will need further time for it to make the rules. We need to identify the problems confronting people, and we have to resolve them. There are difficulties with recovery maintenance fees. People have been calling for an authority on maintenance fees. They have been calling for that over 2 decades, but the government is not doing that. So can we address that in this bill instead of waiting for the FPRC to come up with the rules? We are encouraging mediation between the parties for this bill. But then when it comes to divorce proceedings, maintenance payment, or when it comes to custodial right, in Chinese community, does mediation really work? Does it really do anything for the parties? In the divorce proceedings, people are not happy with one another. Does mediation really work in a divorce context? I would like to hear from the government on this point. And on comments from bodies, do we have the submissions from the different bodies? So first, can we get a response from the government? And as I said just then, for Legislative, we will do consultation. Ms. Kong, you were referring to consultations. I'm assuming you're referring to the comments the government received at an earlier stage. But for us at the Legislative, we will do a round of consultation. So now over to the judiciary to respond to the members' questions. Thank you. We want to stress that we're focusing on the court procedures. We want to consolidate and streamline the procedural rules. For court users, there will be convenience. Things will become simpler. Now there are more than 30 pieces of legislation. Court users have to look up all these legislation to find out which rules they need. So now things are complex and convoluted. Our goal is to have a unified set of family law procedures covering everything from application, the supporting documents needed, the fees, all those procedural steps involving more than 60 parts. All these steps will be spelled out in clear, accessible ways. We're doing all this to make life easier for court users so that they can tell what steps will be involved and they can look things up easily. Now, there will be consultations involving those more than 60 parts of procedure rules. There will be public consultations. And we want to take on board public views. Once the system is up and running, we will do publicity. There will be booklets and also a dedicated website where people can find the procedure rules and the explanation for easier access. So there will be more work to be done on this front. And Ms. Dorenkov mentioned mediation. The judiciary has all along been encouraging the use of mediation, especially in family law matters, on things like money or custodial rights. Over the past 10 years, the judiciary has been committed to the use of mediation to address disputes in family law. There's a working group on mediation with a senior judge leading the group. We encourage the use of mediation at different court levels, and there are also practice directions on mediation. In 2018, we set up an integrated mediation office. Information is available for parties in family proceedings. At any stage of the proceedings, parties can go to the integrated office for information on how to access mediation services. Over the past 5 years, through this integrated office, the success rate is over 60%. For more recent measures, we have this pilot scheme. Mediators help out with the financial disputes starting from 2019 when the top pilot scheme was launched. Mediators were involved. In the middle of a proceeding, say you have financial dispute, the mediator comes in to address the financial dispute. Once the mediation works, the matter goes back to the court. The pilot scheme has helped resolve 90% of the dispute. So now, where appropriate, we take an incremental approach in expanding the scale of this pilot scheme. So the goal is to have a mediator come in on matters beyond financial disputes to help the judge on this case. Any other thing from anything else? No? So now we will hear from Ms. Elizabeth Quat. For this bill, the goal is to consolidate and streamline the procedural rules currently scattered across various pieces of legislation. The point is to give easier access to court users to the procedural rules. Has the government done a large amount of research? Has the government consulted families in family proceedings to find out what sort of problems were confronting them? Where are the problems? Is the government taking a targeted approach specifically addressing those problems with this bill? Judiciary, please. Have you consulted families or have you done extensive research to find out what the users think? Now, for large-scale research, We're focusing on the court procedures this time. We consulted the relevant bodies and also the legal professional bodies, and also lawyers engaged in family law proceedings. Professionals are involved in family proceedings. In public consultations, we also consulted NGOs. David Lau can tell us more.
Mr. Lau, please. Thank you. We can divide that into a few stages. When we had preliminary proposals, there was a public consultation, which was rather extensive. There were over 100 recommendations. And then we consulted the public on that, and we received feedback from different organizations. And then we came up with the final report. The bill is based on recommendations and the final report. To a certain extent, we appreciate that in court, users have issues with the current system, and that's why we have consolidated the current procedures. We have some understanding of problems they face, and so we're trying to streamline and clarify the procedures. As said, we don't really have any legal provisions for some procedures. They are based on case laws and previous practices, and now all these procedures are clearly set out right from step 1 to the end. The forms, the time frame, and the procedures are all spelled out in the bill, and we have practice directions to help as well. As said, we are going to provide more information to the public. We may set up a website to facilitate the public's understanding. So procedures will be very clear in the future. Right now, many parties involved do not know what stage they are at, and they don't know the step to come next. We will have very clear procedures so people can browse our website, or they may have a leaflet with steps for them to follow. Hopefully, that will assist the parties. So in a rather unhappy situation, our procedures will help them to settle them more expeditiously. Ms. Kwok, my concern is whether you can really achieve what you desire to do. I have come across many single-parent families. I have gone through the tortuous family proceedings with many single-parent families or single mothers. The fact is they have no idea. They don't know what's happening. And when the proceedings commenced, they were really shocked by the proceedings. You have to understand that in a family going through divorce, both the parents and children are going through a very difficult stage of life. To many single mothers, they suffer emotional hurt, and they are under financial stress and also the stress to look after their children. And if they have to fight for custodial right with their ex-husband and trying to get maintenance, and they feel that they're being bullied by the procedures, that's their feeling. They might have spent a lot of money and time, and still they cannot recover maintenance. in arrears. So they don't really know what to do next. They don't know what they face and what they can do after they have received a court judgment. They only know afterwards that they have to go back and do this and that, and there is no end to such proceedings. Such cases can drag on for many years, so it's a very painful experience. I'm pleased to see that the government has decided to go through this mammoth exercise. Judging from the thickness of the bill, I can understand the difficulties involved. I want to thank the officials involved. But at the end of the day, we want to know whether these families, the single moms in particular, can get help from the new system. So hearing views from the public is important. After all, we are not the users, and we don't know whether the bill will give them great relief. If we just hear from the legal professionals, their concerns may just be the procedures and not problems faced by the users or the parties concerned. I hope the bill will not just help the legal profession, but the users as well. And I just mentioned mediation. I was told that the effect was quite good. I'd like to know the number of cases you have disposed of through mediation. Having the percentage alone is not really significant if we do not have the actual numbers. Can you please put together successful cases, anonymized, and then you can prepare leaflets for families to know that there are successful cases and they understand that there's a way to dispose of their cases. Even after the amendment, the proceedings are very complicated. I don't think laymen, including the ladies who are going to use the bill, will find it easy to understand. Now we have AI. We should make use of AI. You just ask them to put a question to you they don't know what to do. Now, if you have a set of frequently asked questions and you use artificial intelligence to provide such information to them, I'm sure that will be of great help to families going through such a difficult period. Thank you. Administration, do you have any mediation figures? Now, for the latest trial scheme, and that is the settlement of financial disputes. It started 2019 with the help of mediators. And as at end 2022, there were 24 cases. Success rate was 90%. What about matrimonial matters other than financial problems? We do have such cases, but I don't have the information at hand. I can provide that to members later. Well, there aren't a lot of such cases. Financial disputes are hard to resolve. If the success rate is so high, you should widely publicize the use of mediation. Many people don't understand and may think that it's not going to work. If you have typical cases, you should tell success stories and let families understand that mediation was able to resolve these problems, and they may be more willing to accept this method. All right, Dr. Dick Chi-yun, second round. As said by Mr. Lam Sen-keung, the direction of the bill is desirable. We want to see early implementation as well, but as said by Mr. Rin Kun, the devils are in the details. I think there was some deficiency in previous discussion. As I understand it, public consultation was highly focused. You concentrated on the legal bodies. As said by Ms. Elizabeth Quach, you focused on the procedures. You want to streamline the procedures of family proceedings. But to end users and to stakeholders helping end users, my observation so far is they're not so engaged. Legal procedures is one aspect, but for a family in distress, they need good procedures to help them. And the viewpoints and the experience can be very different from different parties. Chair, I agree that we should discuss public consultation to be done by this Bills Committee. I'm not criticizing previous public consultation, but if we engage stakeholders more, that may even help to improve the bill. As for the FPLC, the committee, my understanding is that it will be mainly be made up of professionals from the legal sector in particular. Can you include social workers, teachers, as well as people engaged in mediation? I'm sure they have a lot of experience and they do understand the hardship of families. Their observations, their views will play a big role in helping to streamline the procedures. So can you consider adding different professionals from different sectors to be included in the committee? Thank you. Deputy Judicial Administrator, can you explain whether you can enlarge the representation of the committee, please? Can other sectors be included? Thank you. First, public consultation. As mentioned by Mr. Lau, in 2014, when the Working Party was working on the report, we started our public consultation, and our responses form the core of the bill here. A committee will be set up to make the FPR. Again, we will consult different sectors at that stage because we are of the view that by that stage we will have more details. So, for instance, there will be a part on mediation, another part on applications and procedures, another part on appeals, etc. So after the details are included in the rules, we are going to do another round of major public consultation. NGOs and different sectors will be invited to give us their views. Perhaps at that stage, it will be more appropriate to carry out the consultation. After all, we need the draft rules with details before people can comment on them. Right now, we know the broad direction. And when we did the public consultation, we did not receive too much views because people in general in support of the broad direction, and then more detailed feedback can only be obtained when we have the rules. What about different sectors to be included in the committee? The composition of the committee, well, we have taken reference from other rulemaking committees, such as the Committee for Making High Court Rules and District Court Rules, because the committee is really responsible for making highly technical court procedures. And court procedures are involved. The committee will model on the composition of High Court Rules Committee and District Court Rules Committees. Will have judges and also representatives from the Law Society, the Bar Society, as well as the DFJ. So we will model on the composition of current rules committees with legal backing. But then we will consult the public on all the rules before implementation. Professionals can comment on the rules at that stage. And we also have a users committee, a committee of family court users. There, we have representatives from the Social Welfare Department and the Legal Aid Department. So the rules can be discussed in other committees. We like to model on the composition of other rules committees in other pieces of legislation.
Chair, I insist that different stakeholders should be involved in the process, and that's how you can have a reasonable process that also shows procedural justice. You need to have different stakeholders, people who actually represent the families. There will be the FPRC, there will be consultations, and then there will be the rules. But how will the gatekeeping work? So that will come to electrical, right? So that will be subsidiary legislation. Okay, then that's also good, all good for me. Next, Mr. Rincon, please. Some questions. One thing of public concern is, say this bill is passed, and then we have a mechanism. Will that mean lower legal costs? Would that mean less fees paid to lawyers and savings in time, in recovery, maintenance, and custodian rights? Would the bill make it easier to recover maintenance? That's my first point. Now, my second point, we want to streamline the procedures. But then Clause 17 of the bill, for some matters, they have to go to the originating court instead of the family court. Clause 17 covers a number of things. The maintenance order, for example, the legislation on the maintenance as well. Then there's also the cohabitation violence regulations, etc. Many procedures are mentioned here. The family court doesn't have jurisdiction, and the matters have to go back to the originating court. So why do we have this arrangement? And then on part 4, to write on Dr. Tick's point, I'm pleased to hear that for part 4, the approach will be like the High Court rules and the District Court rules, subsidiary legislations. But those orders are 400 plus pages in thickness. I believe there will be many pages in the rules for the family court too. How long will the rulemaking take? People are concerned. Last time there was a consultancy study on maintenance. It took years to complete. So if we have several hundred pages of family procedure rules, do we have a timetable? When will this FPRC be convened, and how long will it take to draft the rules? So Judiciary, can you tell us about the timetable? First, the timetable. The first step is to have this bill passed, and then we follow the bill by setting up the FPRC. And then the committee will oversee the drafting of the rules, the procedural rules, that is. And then there will be public consultations. After the consultations are done, some changes may be needed to the rules. And then the rules will be tabled at LegCo. So the FPRC, once it is set up, will proceed full steam ahead with its work. We have to wait till this committee is set up. They will review their work progress. But this will be the overriding, the priority for them. Follow-up question from me, Mr. Rincon. Clause 25 and 26. It's a broad scope when it comes to the committee. It covers pretty much everything from cradle to grave. We're working on this piece of principal legislation, and it's a very wide scope. Say, in the title registration system, it took 20 plus years and the system is not in place yet. My concern is that it will be a very contracted process and we don't have the rules even after all those years. Let's take divorce as an example. There are disputes over maintenance. After this bill is passed, and then we don't know how long it takes to have the rules. So in between, say we want to propose ways to speed up the recovery of maintenance, and then the government counters by saying that they're working on the rules, then wouldn't that end up delaying the process? I'm not chasing up the committee. I know the committee will be working hard, but my concern is that if it takes 10 years to make the rules, and then any reform in the system is stalled, just like what happens with the title registration system. So can the government give me a response on what will be done about this problem? Judiciary, please. So let's look at the matter separately. For the rulemaking, the work involves consolidating existing procedural rules in the laws. So we're not making something new. We're consolidating the existing procedural rules that will be streamlining, improving. We're talking about many existing rules. Those court procedural rules are based on the existing rules. So we're not drafting something from scratch. As we consolidate the rules, we will improve and streamline the rules. On policy matters like recovery maintenance, ways to improve the mechanism, etc., those matters rest with the relevant policy bureaus. So the work on one side will not impede the work on the other. Say there's a new policy, a new bill, the bureaus can go ahead. And it's just that the latest rules will be incorporated into the rules, the procedure rules. So neither side will impede the other in their work. It's my turn. Members have made some comments. I want to bring up something from before. So here's my observation. There are procedural rules scattered across different sources. The government wants to consolidate them. Consolidation, collating. Does that really mean greater convenience for the court users, though? That's the point of focus today. The bill here is about consolidating the procedural rules. As for the legal principles on maintenance, for example, those substantive matters fall outside this amendment exercise. This point needs to be made clear. Just then, Mr. Rincon and Ms. Elizabeth Quat talked about maintenance. Those points have to do with policy or some cases in the past. Those points will be dealt with elsewhere. But here, for our current purposes, we focus on consolidating the procedural rules to streamline the process. But I think the members have made a valid point. We talk about the procedure. Does that consolidation translate into greater convenience, greater ease for the court users? That is, less convoluted rules. So here's my observation. I believe more members will speak on this bill. So the point is, how do we explain the matters to the public so that after the consolidation, the end users can see they can save time and there will be greater convenience? Take the West Kowloon Law Court, for example. I've been following up on the point about the Small Claims Tribunal. The jurisdictional limit is raised from $50,000 to $75,000. That helps a lot of people. I bring up this example for a reason. For the layperson, they have little clue as to how to proceed. You cannot hire a lawyer at the Small Claims Tribunal. The Small Claims Tribunal has done a great job in one thing. They put a form there. People can ask the front desk what they can do, and the front desk provides useful advice. From that experience, we can tell people find that helpful. For the bill here, we are consolidating procedures. We want to have a unified set of rules to bring convenience. Sure, that's the direction. But then we also want to achieve this. When the court users come to the family court, now for sure there are differences between the Small Claims Tribunal and the family court, but then the front desk of the Small Claims Tribunal has provided helpful advice. Just by way of declaration, my own law firm also works on family law issues. Not everyone has access to lawyers. But can we provide some advice to people, especially for those people I just mentioned? Now I turn to a different point. For the composition of the FPRC, those are legal professionals, people from the Law Society and the Bar Association. But what about people who can reflect the views from other sectors? Say people from the welfare sector who have come across cases, or people in mediation. The judiciary told us they are modeling this arrangement on the High Court Rules Committee. But there's a distinction here. For the High Court and District Court Rules Committees, that for the High Court, the jurisdictional limit of the District Court, say you raise it to $3 million, so more cases will be handled by the District Court. Professional bodies were consulted. For lawyers, we take part in the process, we get the point. But then, in the context of the family court, it's different. Because with the family court, any change has wider implications for the public. So given these unique circumstances here, do we need a difference in the composition? So that's just an observation, and that's my comment. Okay, we have a response from the judiciary. Thank you.
Thank you, Chair. When it comes to the composition of the committee, we accepted the views of the HLS panel. We added representatives from the legal professions. So at first, the instead of one from the Law Society, the Bar Association, respectively, we have added that to 2 so that we can have more expertise and also people knowledgeable in family proceedings. And then there can also be experts in mediation joining the committee. So we have adjusted the composition of the committee accordingly. We've also got a committee of family court users. They will not just discuss the rules, but the management facilities of the family court, etc., will be discussed by the committee. We have representatives from the SWD Legal Aid Department and also legal representatives there. They will discuss the rules as well as the facilities. I think it is better if we have a committee of users. The functions and roles may be different from that of the FPLC, but still it will be consulted, and this is the way we have been doing it all along, and that will be smoother, and that is already a proven mechanism. We suggest that we use the committee of family court users to comment on the court proceedings and court facilities of the family court. That will be a better way of doing it. So you're saying that perhaps you should collect the views of users through the users committee, right? Dr. Dick, third round. Thank you for giving me the third round. I've already raised a few issues. First, I insist that there should be different stakeholders included in the committee. Is insufficient if you just include the perspectives of lawyers, because there are professionals who are more familiar with problems faced by these families, and they should better be included. I hope you won't say no to this proposal today. I expect another answer at the next meeting. Yes, it's good that we have a time frame. If you do not give us any undertaking in the council on the commencement timetable, then it may not be that desirable. Can you tell us, say, within 3 to 4 years, you can come up with a draft? We need an undertaking or a pledge to the council so we can be more confident. Don't tell us that the matter will be referred to the committee. Can you give us a rough time frame when we can have the draft rules for discussion by the community? This point was raised previously. Judiciary, do you have anything to add? Thank you, Dr. Tick, and thank you, Chair. The time frame. Now, as we said, there are different procedures to go through. When it comes to the draft rules, the committee will start working on them as soon as it is established. Our optimistic assessment is that the rules the draft rules will be available for public consultation within 1 or 2 years. Ms. Doreen Kong, thank you. Administration, please clarify. You have to make the rules. Will there be practice directions? Yes. Where is it mentioned in the bill that the committee will make practice directions as well? And what is the distinction between the rules and practice directions? Mr. Lau? In Clause 22 of the bill, we say that the Chief Justice may make directions as to the practice and procedure of the court on one or more types of family proceedings. To elaborate on that, For the rules on a particular type of matters, we have a practice direction to deal with it. So if you want to know the directions for a particular type of family proceedings, you refer to this practice direction. You don't have to look up different pieces of legislation. The practice directions will provide more information and also specify forms. So we will have a set of rather comprehensive and standalone practice direction for each type of family proceedings to facilitate users how to proceed and also the basis to follow. Thank you. The reason I raised this question is because I'm a bit worried. I mentioned Singapore. They have got both rules and practice directions. The practice directions used by Singapore are very comprehensive. My worry is already painful going through a divorce. If we have both rules and practice directions, which are very lengthy in Singapore, where the practice directions were written mainly for laymen. Now, I understand that it will be for the Chief Justice to make practice directions. The committee is only responsible for making rules and not the practice directions. I raise this question because I'm worried about the delineation of duties. When will we have practice directions? When will we have rules? Because the CFA will make practice directions. Will they have to wait for the rules to be ready before they can make practice directions? They will be done in parallel. The committee will also see to that. The Chief Justice is only the authority to make such directions. The committee has the right or the duty to make the practice directions. Where can I find the bill that the committee will make practice directions as well? Of course, it will be much efficient if the two are done in parallel. Where can we find the bill that the committee is also responsible for making practice directions? The FPLC has the power to make the relevant rules. And in clause 22 of the bill, the Chief Justice will also make practice directions. Yes, I see that, but you just told us that the committee would also make practice directions. I don't see the authority here. Our thinking is when the committee is making the FPL, we will be providing practice directions to the committee for its reference. The committee doesn't have the power to make the practice directions, but they should make reference of the PD. So the rules and also the PD will complement one another. So the committee will oversee the practice directions as well. Of course, the power to make the PD rests with the Chief Justice. It's not that the two are totally unrelated. The two will complement one another. The purpose of making the rules is to have a set of standalone and self-contained procedures for users to follow easily. So in making the rules, the committee will refer to the PDs as well. And there will be interaction between the judiciary and also the committee. We will not wait until the rules are ready before the PDs are made. When the rules are passed by the council, by the LegCo, will the PDs be submitted to us for reference as well? Mr. Lau, hopefully that will be done, because the PDs are useful reference and can provide a better understanding of the implementation of the rules. Where feasible, the PDs should be made available to the LegCo. There should be a more desirable arrangement. And when the rules are made, the PDs will come into effect at the same time. So yes, it's quite a good arrangement if we make available the PDs to the LegCo together with the rules. Allow me to make a comment. I think we have already gone into the clauses of the bill. Shall we do this? This morning, we have a clear understanding of the rationale behind the Family Procedure Bill. We understand the objective of the bill. Of course, we have views on the formulation of the bill. We have some suggestions and how, after consolidation of current legislation and for rules to be made, the system should be made user-friendly. I think it is the common wish of members here that they want to achieve this. I hope you can understand this. And Ms. Doreen Kong mentioned the PD's practice directions. Now, I think a decade or so ago, there was a civil justice reform. And back then, there were a lot of changes to the rules, including the introduction of mediation at certain stage of proceedings. A decade or so ago, when we worked on the civil justice reform, there were a lot of discussions within the legal sector, and then there were changes to the rules. Of course, I am not talking about an apple-to-apple comparison, but perhaps procedural-wise, there are common points. So can you put together a paper for us to facilitate our understanding and for comparison purpose? Now, some housekeeping. The administration has done its own share of public consultation, but from the perspective of the Bills Committee, we can do our own consultation. Some members mentioned the views of users and how we can ensure the users find the new system user-friendly. So I propose to conduct a public hearing to allow stakeholders to express their views. I can work out the time of the public hearing with the Secretariat. If members have no objection, I think this is the way we should proceed. Dr. Dick. Chair, I support your proposal.
For points of law, people in the grassroots may have difficulty understanding those points. There are groups serving single-parent families. There are many such groups in the welfare sector. These groups are involved in family proceedings. Can the Secretariat write specifically to these groups? Can the Secretariat be more proactive in inviting these groups? You can put forward a suggestion to us, and then we can invite them to express their views at the public hearing. Then we can hear from the end users, members of the public. Ms. Doreen Kong, please. I have a separate question. Can the government share the submissions from the Law Society and the Bar Association they received earlier with us? So for the Deputy Judicial Administrator, have you received the submissions from the Law Society and the Bar Association? Can you share those submissions with us? We will arrange that. So can the judiciary give some thought to this? I will also invite the Law Society and Bar Association to join us at the public hearing. Now, we have dealt with the point about the public hearing. If members have no objection, then let's get started with the clause-by-clause scrutiny. The goal of this amendment is to consolidate the procedural rules so that we can have a framework. We streamline the procedure. We're not making changes to the substantive law or complex areas like maintenance. So this is what the bill is about. When we come to the clause-by-clause scrutiny, some members may have questions about specific provisions. So let's move on to the clause-by-clause scrutiny. If members have no other questions, I will now invite the government to walk us through the changes. So there's a marked up version that's tabled. So we're using LC paper number CP bracket 4211/2023 bracket 01. That's the marked up Chinese copy. Please start. Mr. David Lau, please. Chairman, Clause 1. I'm sorry to interrupt you. A reminder to members. For the clause-by-clause scrutiny, there's a point here. I'm sorry. I need to check. I need to talk to the Secretariat about something. Mr. Ambrose Lam, you have a comment? Chairman, I have this marked up copy. We start with 0001, but I have a paper with a serial number that ends in 02 instead of 01. Just then I said I support a speedy scrutiny and approval. Since you have said that there will be a public consultation, so I think we should listen to those views and then we can get a full picture of things. Mr. Rincon. Chairman, I agree. It's just a few days since we agreed to set up this Bills Committee, and now we're having the first meeting. This bill is more than 200 pages thick. We don't have the submissions from the Law Society and Bar Association in earlier rounds of consultation. I fear we're not fully prepared to get started. It will take quite some time for the scrutiny. Of course, we need to pick up the speed, but can we get access to the previous submissions so that we get a more comprehensive view? Some other members are waiting to speak. Dr. Tik Chi-yun. Chair, I agree that we should listen to public views, and then we are in a better position to scrutinize the clauses. I note members' views. We spent much of today talking about the matters of principle. We don't have a lot of time left. So I will take on board members' views. We will be doing a public consultation. So I will work with the Secretariat to deal with the date of the public hearing. And then people will get to speak. At that point, the government can also provide further information, including the submissions from the Law Society and the Bar Association. The government can share those submissions with members. And then we will come back to the clause-by-clause scrutiny. We have little time left, so I think that's something we can do. So that's my decision. There's one housekeeping matter, though. When we move on to the clause-by-clause scrutiny, we have something to sort out. For the markup copy, the paginated marked up copy, that one is more handy. But for the blue bill, this one may not work so well. I was in many bills committees at the last term. So I just want to make sure we're all on the same page. Let's all stick to the marked up copy. This is something from my experience. I want to make sure everyone has easier access and everyone's on the same page as we go along. So that's the housekeeping matter I was referring to. So now we have dealt with all these matters. Date of the next meeting. Let's do this. We will do a public consultation, that is public hearing. I will talk to the Secretariat, and then I will circulate a notice on the date of the public hearing and the date of the next meeting. So I will see members again at the public hearing, and then we can hear from you. Some members may want us to invite particular groups to attend the public hearing. Please submit the information to the Secretariat. We will be sure to invite the Law Society and the Bar Association so that we can hear from them. So let's stop here for today. Any other business? Nothing. So we will adjourn the meeting here. Thank you.